Good morning, good afternoon, good evening, depending on where you are. On behalf of the Center for Chinese and Comparative Law, I would like to warmly welcome all of you from possibly the region and other parts of the world to attend this symposium. As you can see from the program, we have brought together a group of internationally distinguished scholars. Most of them are the young stars in Chinese legal studies. They are young stars, but at the same time, very, very well established scholars. So they will discuss from different perspectives, the nature and the function of law in China in light of a global trend which some people would characterize as the rise of authoritarian legalism. Before the discussion starts, I would like to thank, in particular, my colleague, Professor Peter Wang Shucheng, who is also the moderator for the whole session this morning. It is his foundational thoughts and the leadership that make the symposium possible. And from the perspective of the center, we are very proud that we have been able to provide a dynamic and independent forum for academic ideas on Chinese and comparative law to be presented, analyzed, and criticized. A few words about the research output of this event. We didn't ask the speakers to submit a very long, full-length law review article as they would usually do, and they are good at. Instead, we would want to publish a mini symposium in an internationally refereed journal in which each speaker is expected to contribute a short essay of not more than 5,000 words. With all that, I would give the floor to Peter. Shucheng, please.
Thank you, Zhang Yu. Okay, good morning, everyone. It's my great pleasure both to moderate and participate in this panel with our distinguished guests. As you can see from the program, we have 6 speakers, including me, in this panel. And our distinguished guests actually need no introduction, so I will be very brief. Our guests are Professor Taisu Zhang from Yale Law School, Professor Sida Liu from University of Toronto, Professor Hualing Fu, Chair Professor and Dean of the Faculty of Law of the University of Hong Kong, Professor Samuni Satling from the Chinese University of Hong Kong, as well as my colleague, Professor Jiang Yu Wang, and me. And I will ask each speaker to present for 20 minutes, then followed by the Q&A session. Without further ado, now I'd like to invite our first speaker, Professor Taisu Zhang, who will be speaking to us on legality and legitimacy in contemporary Chinese politics. Professor Zhang, please.
Thank you. So before I start, please allow me to thank both Professor Wangs for organizing this very interesting and intimate event. It's good to see lots of familiar faces and good to meet new friends. So I take it that I should speak for roughly 20 minutes, or do you want me to speak for less than that and then like leave 5 minutes for Q&A?
Yes, 20 minutes, yeah.
Okay, good. So the topic that I want to talk about basically today is the question properly framed is whether there is such a concept called as quote unquote pure legality, and whether legality thus defined in a relatively pure sense is capable of generating relatively large amounts of perceived political legitimacy frankly, generally speaking, any regime, but specifically in the Chinese context. And the claim that I want to begin to defend in this paper and one other paper that I'm writing with some friends is that contrary to pretty common assumptions that you see in political theory and legal theory, there is pretty good reason to believe that quote unquote pure legality can generate large amounts of perceived political legitimacy in the Chinese context, and there is at least like some reasonable possibility that it can also do so in other contexts, in other countries. And of course, so the background for this project has to do. It's anchored in something that I've written about before with Tom Ginsberg, which is this perception that I have and some others have that since 2014-ish, the Chinese government's been making quite substantial investments in what we call legality. Right, so I don't think there's any reasonable case to be made that China is becoming a kind of like a rule of law society, or that there is any chance of constitutionalism emerging in the Chinese context. Nonetheless, the government seems to be serious about investing in legal professionalism, in the predictability and consistency of adjudication, and in ensuring some measure of kind of like controlling administrative and bureaucratic action through legal rules. Of course, the slogan that they give for this is "依法治国," which is one of the biggest slogans of the Xi era. And at the very least, like I and some of my friends take the slogans relatively seriously. We see it as something that's actually being backed up by substantial institutional investment. Now, I understand that this is not necessarily like a non-controversial claim. Yet, having followed some of the recent literature that followed my article with Tom Ginsberg in 2019, recent attempts to kind of empirically re-examine whether the Chinese government has actually been making progress towards legality seem to have concluded that yes, implementation of these 依法治国 measures have been imperfect. But first of all, things from kind of like a legality perspective, there's obviously no evidence that things are getting worse, and at least some reasonable evidence that to some extent things are in piecemeal fashion getting better in certain regions. So like overall, the picture is kind of like slowly turning towards this broader legality ideal, even at the kind of more basic level of actual implementation. Now, the one clear thing about this entire 依法治国 campaign has been that it's not just meant to pursue bureaucratic rationality or more efficient administration and so on and so forth. It's meant as a popularity campaign. It's meant as a campaign that in the minds of these policymakers can enhance public support for the party state and specifically for Xi himself and his policies. So what seems to be happening is that like this entire 依法治国 turning towards law, pro-legality trend, whatever you want to call it, it seems to be making a bet that this kind of measure can produce a boost to the party state's perceived political legitimacy. And of course, that begs the question: is that bet likely to actually materialize? Are they likely to be correct in making that kind of bet? Now, of course, even more broadly, I think most of us would also freely admit, except for unless you're kind of like a diehard supporter of the regime, most of us would likely have to admit that in many aspects, civil rights and civil freedoms in China have not been getting any better in the past couple of years. Much more likely, they've been deteriorating in certain fashions. So this is an interesting case where the government seems to be making investments in legality, but at the same time, not only is there no substantive expansion of actual civil rights and freedoms in these in substantive terms, but there may even be a deterioration of those rights and freedoms. Now, this is less common than you would think. Most regimes, even authoritarian ones, when they pursue pro-legality measures, tend to also at the same time pursue some at least like piecemeal or moderate expansion of civil freedoms, of civil rights and civil freedoms, at the very least economic rights and economic freedoms. In the Chinese context, there is not even a hint in the past couple of years that economic freedoms have really substantially expanded in any measurable way. So it's really a pretty, not quite unique, but it's quite an unusual circumstance in which there seems to be movement towards legality, but movement away from the kinds of substantive rights and freedoms that we would associate normally with a thicker ideal of the rule of law. And at the same time, because of what happened in 2008 with the Constitutional Amendment, with the constitutional amendments, we can also likely say that if you define rule of law as basically some kind of like checks and balances constitutionalism, then China is also moving away from that ideal type as well. So it's a context in which you're moving towards you seem to be moving towards legality, but away from the rule of law. Now, in that context, right, is the bet on legality as a legitimacy generator likely to succeed? So before I go on, let me just very briefly define a couple of concepts. Like there are three concepts that get tossed around in this kind of discussion: rule of law, rule by law, and legality. Rule of law is the thickest one, obviously the most substantive one. Very often it's associated with using law as a means to reliably pursue liberal democratic ends. But even a thinner version of like a definition of rule of law at least incorporates some expectation that law will be used to constrain the regular exercise of power by the highest political actors in the country. Right, so in the Chinese case, the reason why you would never say China is moving towards the rule of law is that right now seized power is less checked by law, or at least as unchecked by law as any of its predecessors ever was, and perhaps even more so. The fact that the top regular political actor in the regime is effectively both nominally and de facto unchecked by legal rules basically excludes China from any possible category of rule of law, even a thinner one. So rule of law is not merely regular enforcement of laws. Rule of law is like using law as a check against political power. At the other end is this concept that we all talk about and have used, perhaps abused over many decades of academic discussion, called rule by law, which people talk about especially heavily in the Chinese context, which basically just seems to suggest this is the party state using law to govern society. It's mainly that the party doesn't subject itself to law, but it subjects society and private parties and so on and so forth to law, so that it has an easier time controlling their and regulating their actions. Legality is somewhere in between these things. Legality basically just means, in the pure Weberian sense, it just means regular, predictable, rational professional enforcement of the written law. It passes no judgment on how expansive those laws have to be, right? So if the laws themselves don't purport to check the power of Xi Jinping, then that's fine. That would rule out the rule of law, but it would not rule out legality, because the laws themselves, you can still enforce the laws technically and rationally without violating the letter of the law, and yet without checking Xi's power. It's also a bit more than rule by law, because it presumes a certain measure of perhaps sincerity is the right word on behalf of the rulers. They actually really want to enforce the laws, and very often they enforce the laws, especially in the Chinese context, against pretty much most parts of the bureaucracy, even to some extent large parts of the party, except the party leadership, right? So it's only a relatively small number of very high-level political actors that are not really subject to legal constraints. Everyone else is, and there seems to be some interest these days in the party to actually make good on those kinds of rules and to actually enforce them in some kind of some substantial way. Now, if you look at the political theory literature on the connection between law and legitimacy, people tend to think, of course, rule of law, when it's actually realized, can produce large amounts of legitimacy. Especially thick rule of law that enhances liberal democratic ideals, civil rights and civil freedoms, and so on and so forth. That clearly generates a large amount of legitimacy when it's actually realized. At the other hand, like on the other hand, most scholars tend to think that if you don't have that kind of like thicker normative dimension, if you're not protecting civil rights and freedoms, if you're not checking the exercise of power by the highest political actors in the land, then simply enforcing the law will not necessarily enhance the state's popularity or make the state more legitimate in the eyes of the public. There are complicated reasons for why scholars have thought about this. Part of it is in some ways like this entire literature about like law and legitimacy in the post-World War II context has largely been wrapped up in this overall discourse of liberalism. And it has a strong bias towards thinking that non-liberal regimes cannot be legitimate, cannot either be normatively legitimate nor, as a matter of social perception, legitimate in the eyes of the public. And as part of that, they would therefore also want to basically deny the possibility of just raw enforcement of law without certain kinds of liberal democratic ideals as potentially being a substantial generator of legitimacy. At the same time, there is a sense amongst many political theorists that populations care about outcomes. They care about substantive outcomes, not so much the kind of like process of enforcing law. They care about they care about things like dignity, respect, liberty, good economic outcomes, and so on and so forth. And law enforcement matters for legitimacy only insofar as it actually enhances those substantive ends. It turns out that I'm actually running out of time a little bit, so let me speed up. The claim that I want to make in this paper and also in this other empirical paper that I'm writing with a friend at Stanford is that we think that this is this assumption that only thick rule of law is able to produce legitimacy and pure legality, stripped of these like thicker normative commitments, is likely incorrect, perhaps across the board, but especially in the Chinese context, there are strong reasons to think that it's incorrect. This argument has two components. On the one hand, so this political scientist friend of mine at Stanford named Xu Yixing and I have been running a survey experiment in China for the past 6 to 8 months. And we only got our data about 2 weeks ago, and we've been analyzing it. The data seems to suggest that pure legality, right, like enforcement of law, like regularized professional enforcement of law, even of laws that are themselves quite unpopular, for example, internet censorship laws, even for those kinds of laws that are inherently socially unpopular, regularized enforcement, like reliable enforcement, investment in professionalism and legal training and so on and so forth, those kinds of things brings a not terribly large, but nonetheless sizable and significant boost to the perceived legitimacy of governmental institutions. The boost is not quite as large as some of these like thicker things. It's not as large as like, say, procedural dignity and so on and so forth, but it's not nothing. And this finding of pure legality being at least a moderately significant legitimacy generator is quite at odds with the way the empirical literature has been headed in the past 2 or 3 decades. Now, of course, we have not had time to fully analyze these results, and all these claims are preliminary. But assuming that these results hold, which I think they will, the second strand of argument that I want to push is that from a historical perspective, from a qualitative analysis perspective, if you're a person who knows the history of China's reception of law, who's tracked the way that Chinese political elites have been talking about law since, like, I don't know, 1898, then this never should have been that surprising in the first place. And this rests upon 2 different strands of arguments. The first is that as a general matter, like, I think there are good theoretical reasons to think that pure legality is something that's generally socially desirable in the vast majority of countries. for the simple reason that pure legality is perhaps one of the most important enhancers of legal predictability and the reliability of enforcement in modern, like under modern state regimes, and that's like a generalized social good almost anywhere in the world. But even leaving that aside, like leaving that kind of instrumental perception of reliability as of legality as an instrument of reliability and consistency aside, in the Chinese context, there are deeper reasons to think that pure legality has long been considered something that is inherently politically good, even when it's stripped of its like liberal normative commitments. And this argument, just you think about the way that the idea of law was initially received into Chinese political discourse in the late 19th century. You read people like Liang Qichao or Kang Youwei, or even high-level officials like Zhang Zhidong and Liu Kunyi and so on and so forth. When they talk about law, right, they speak of like whether it's elite intellectuals who are not in the government or elite intellectuals inside the government. When they speak of law, they speak of law in kind of like a they don't speak of any kind of like liberal legal ideal. Instead, they speak of law simply as a measure of control. It's a technical, formalistic measure of lawmaking and rulemaking and enforcement that they understand as something that may or may not be attached to these broader Western liberal ideals, and can, in the Chinese context, properly be understood simply as an instrumental pursuit of regularity of enforcement and the rule of the use of like legal instruments to pursue social control. Now, of course, if you trace some of these people, for example, like Zhang Zhidong, like you clearly see the way that he understands law is strongly influenced by what he understands to be the legalistic tradition. He equates Western law with Chinese legalism, even though the equivalence is not actually strong by any definition. Because you could almost argue in John's case, because of because the way that he conceived of law was strongly shaped by legalism, which itself is not certainly like it's the furthest away that you can possibly imagine from kind of like a liberal legal ideal. It's strictly legal institutions in service of the ruler, in service of the state, because that's the way that he understands legality. Once you introduce the ideals of Western law into his discourse, that's kind of the frame that he's inclined to understand Western law under as well. So from the very beginning, the Chinese intellectual understanding of what law is was always kind of like legalistic in a Chinese sense as well. It was this merger of Chinese and Western intellectual traditions, which produced what you might call kind of like a normatively emaciated notion of what law was and what law's role in society properly was. Which meant that if you trace the early 20th century Chinese political discourse, elite discourse on like what was the role of law in modern societies, what was the benefit of law, and so on and so forth, people didn't talk about law as a means of facilitating freedoms or economic outcomes or whatever. Like law itself was simply seen like following the law, following like formal legal commands rather than informal social customs and so on and so forth. Those things were seen as inherently modern and something that was inherently desirable by a modern state. So I'm still doing this kind of historical tracing, but like as far as I'm concerned, like there's a strong reason to think that kind of conception of law still is pretty influential. Has always been influential in Chinese elite discourse throughout the past century and 20 to 30 years. The way that law is conceptualized in elite discourse is not liberal for the most part. It's this kind of like technical instrumental thing that's inherently attached with kind of like more technocratic, autocratic notions of modernity, and therefore, like in this kind of general context, assuming that these kinds of general elite discourses have some influence on the way that society perceives the rule of law, you would expect that pure legality, is thought of in this discourse as inherently a social good, even when it's separated from liberal democratic ideals. The second reason why I think that it never should have been that surprising in the first place that pure legality can produce legitimacy in the Chinese context is China is one of the very few countries in the world where the central government is held in higher regard by the population than local governments are. The vast majority of other countries on earth, people tend to trust their local bureaucrats more than they trust central level policymakers. Local bureaucrats are closer, more transparent, more easily observable, perhaps more accountable. China's the opposite. Like everyone has a higher view of the guy in Beijing than your local provincial or county level bureaucrat. Now, because of that, right, given that law itself is seen as coming top down from the center, as opposed to like local rules and regulations and orders and so on and so forth, it's like I think it's not that so surprising that people associate law enforcement with something that's inherently good, so inherently better than the kind of like on the grounds, more detailed oriented, more contextualized everyday administration that you get from your local bureaucrats, right? Because you don't trust the local bureaucrat nearly as much as these better educated, more elite central policymakers. You put those two reasons together, and I think there's a pretty good contextualized and qualitative reason to think that the way that law is discussed and conceptualized and fit into this general social perception of the state, there's pretty good reason to just think as a qualitative matter that pure legality should be able to generate some amount of political legitimacy in the Chinese context. And of course, we have been trying to prove this empirically and quantitatively through these survey experiments. So I'm going to stop there. And thanks again for inviting me.
Thank you very much, Taisu. This is fantastic. Okay, so now let me turn to Professor Shi Daniel. He is going to speak on Cage for the Votes on the social transformation of Chinese law from 1999 to 2019. Sida, please.
Thank you, Professor Wang. Let me share my screen. I don't have a sophisticated PowerPoint, but I do have some pictures and mostly cartoons that I want to show that during my presentation. Okay, is that working? Okay, great.
Very well.
Yeah, great. So as Professor Wang said, I'm presenting a paper I actually just published a few weeks ago called Cage for the Birds on the Social Transformation of Chinese Law. So the idea of this paper is not really to present any new evidence or empirical data about Chinese law or Chinese society, but rather to use the paper as an opportunity to reflect about some changes that happened in the Chinese legal system in the past 20 years. So of course, I'm not the first person who talked about birds and cage in the context of Chinese law. 20 years ago, Stanley Lubman, who's a professor at Berkeley, wrote this classic book called Bird in a Cage, Legal Reform in China After Mao. And this, until today remains one of the classics writings on Chinese law. Basically, its overview is not just about Chinese legal system after Mao, but also Lubman actually started from the Mao era and then move on to the reform era. And one of the core arguments that Lubman made in this book, published in 1999, actually, that's why I started from 1999, because I want to kind of engage with this book. But Professor Lubman basically made the argument that why he called the title Bird in a Cage. He used the metaphor to refer to Chinese law as a bird, as a little bird, kind of trapped in the cage. The cage, of course, is Chinese politics, the so-called Chinese characteristic, all these institutional constraints that Chinese law was kind of being constrained. So that was kind of the original bird in a cage metaphor. Of course, Lubman, used this metaphor because he was referring to Chen Yun, one of the senior leaders in China in the 1980s. Chen Yun was using the bird in the cage metaphor to refer to the economic reform, the economics as the bird, and then trapped in the cage. So he said, the economic reform was going too fast. The bird should be confined in the cage. And Lubman was basically lamenting the fact that almost 20 years after Chen Yun said that, used that bird in the cage metaphor, by the late 1990s, what he observed is that the economic reform has, really took off in China, especially in the 1990s. But the legal reform was still kind of is the bird trapped in the cage, right? So that's kind of the idea. But what struck me when I was rereading this book 2 years ago, in 2019, that's kind of the end of my article, before the pandemic struck, of course, and is that I realized very clearly that it's very hard to see Chinese law or Chinese legal system as a bird in 2019 or in today, 2021. So the Chinese law is not really a little bird kind of chirping and stirring in the cage, try to break out of the cage, kind of leads to something, no matter called the rule of law, rule by law, or legality, legitimacy, as some of this theoretical ideals that Tai-Tzu just talked about. But it actually became a cage in itself that traps other birds. So that's kind of where the cage for the birds metaphor I just talked about came from. And so of course, the question is, what are some things that changed in Chinese law after 1999? So here, I want to first show you two quotes. One from Lubman, from the concluding chapter of Lubman's book. He said, because of the absence of unifying concept of law and the considerable fragmentation of authority, China does not have a legal system with the kind of word system emphasized. So what basically Lubman was saying that the reason he said China doesn't have a legal system in the late 1990s because the authority is deeply fragmented and the concept of law was not unified, which was kind of to some extent it was true at that time, because I happened to be in law school at Beida at that time in the late 1990s. I still remember that, for example, the first contract law, the unified contract law in China, was only made in 1999 when I was a second-year law student, right? And other major Chinese law, for example, property law, or most administrative law in China, except for the administrative litigation law, was not even there, right? They were not even made by the National People's Congress yet. So there was a kind of a fragmentation of the kind of different fields of Chinese law. I mean, the civil law, of course, is another example. The Unified Civil Code was only passed, last year, right? So that's kind of, it took a long time for the different branches of civil law to come together to have a more unified legal system. So I think those are some of the things Lubman was talking about at that time. But then if you compare this quote to the next quote, which is a speech by Wu Bangguo, who was the chairman of the National People's Congress in 2011, he actually basically in that NPC meeting in 2011, Wu Bangguo declared that basically the construction of the socialist legal system with Chinese characteristics has been already complete, and there's law to abide by, basically 有法可依 in Chinese, in China's economic, political, cultural, societal, and ecological construction. Basically, 12 years after Lubman wrote the Bird in the Cage article, the chairman of the National People's Congress basically declared, now we have a complete social legal system was completed, right? So if you compare these two quotes, the contrast couldn't be sharper, right? But of course, from my perspective as a sociologist of law, I actually find both quotes actually imprecise, to say the least, because if you think about Lubman's comment, even if we're not looking at the Chinese law, we're looking at the U.S. law or German law or Japanese law, there's always a fragmentation of authority. There are always a considerable fragmentation of authority under the kind of unified concept of law. So there's never a kind of like an abstract unified concept of law there. But at the same time, what Wu Bangguo said about the 有法可依, there's a law to abide by. From a social legal perspective, that's only the very first step in having a highly functional and rational legal system. Because I mean, we have to go beyond just look at law on the books to look at how law actually works in practice, right? That's one of the most basic insight for law and society scholarship, right? So then, of course, if both of these assessments are imprecise, then what will be a kind of a different way to think about what actually changed in Chinese law in the past 20 years. So in my paper, I actually proposed there are two things, I think two processes that characterize the change of Chinese law from 1999 to 2019, basically in the past 2 decades. Basically, as a metaphor, converted the bird of Chinese law into a cage. It's a much larger and harder and also more actually instrumental cage. The two processes are what I call internal institutionalization and party inscription. So internal institutionalization refers to the fact that many major Chinese codes was actually made precisely in those periods, roughly a little earlier than 1999, roughly from the mid-1990s to the early 2010s. That's why Wu Guangguo made that announcement in 2011 that China we finished the construction of the socialist legal system, right? Because during that time, about roughly 15 to 15, 16 years, there are a lot of really important codes, contract law, property law, I mentioned, law on corporations, and most administrative law. They were all actually made, the major PRC code would actually became a lot more complete than in the late 1990s. But of course, and then of course, as a result, that significantly improved the internal coherence and formal rationality of the legal system. So if Lopman was writing his book, not in 1999, but in say 2011 or 2015, he will probably have a little different assessment about the kind of the internal coherence and the formal rationality of the Chinese legal system. So that's what I call the internal institutionalization. But at the same time, there's another process actually going on, actually continued until today, especially after 2012, after Xi Jinping became the central leader. The Chinese Communist Party actually became a lot more assertive in actually in asserting its dominance over the legal system. What I mean by this is that if you think about China's legal reform, we've been probably 40 years into the legal reforms now. The first 30 years or so, the entire so-called reform era, from the late 1970s to the probably the Hu Jintao era, the Hu Jintao Wenjiabao administration, what you see is that the Communist Party, of course, the party is always above the law, always kind of have the final say about the Chinese legal system. But at least there's a veil of law, by which the party was hiding itself. So in other words, the party is in control, but the party is actually not in the law itself. You except for the constitution, of course, you find the Communist Party in the preamble, these places. But most places of Chinese law, you actually do not find the party. And if you look at even the legal institutions, I mean, for example, the legal profession, I studied Chinese lawyers. I mean, the party was actually not very visible in the legal profession. And only about less than 30% of Chinese lawyers used to be party members. Now the percentage is actually higher. It's probably 35%. It's still not very high, right? So for a long time, the party was actually not actively asserting, its visible power over the legal system. But that actually started to change in the past decade, basically. What happened is that now you see the parties playing a much more active role in, what I call inscription. Inscribe itself as the explicit and supreme power in the Chinese legal system, or now the legal system has become more like a cage rather than a bird. So it's actually inscribed the party's name on Chinese law. And of course, there are many examples, not just like the constitutional change, like in 2016 that a lot of people talk about, but also in the judicial reform, in the bar exam, and also in the way that the party, for example, set up party cells, party committees in law firms, in the bar associations, in all kinds of other places. So the party is actually a lot more visible today than 10 years ago or 15 years ago. So I think that's a really important change. That actually make the legal system actually, this actually goes back to some things I think Tai Su said earlier, because I mean, although you can argue that the legal system is actually become a lot more coherent, a lot more rational, in terms of legality, is actually a lot more advanced than 20 years ago. But I think that at the same time, you also see the kind of the political dominance of the party become a lot more visible. Some people might argue that's just a symbolic thing, right? Of course, the parties has always been in control, but what I'm trying to say that formality actually matters, because when the party was hiding behind the Chinese law and the legal system, there's still rooms, I think, for the kind of the reformers or the people who are pushing for a certain kind of reform to claim that Chinese law has certain kind of legitimacy or autonomy, at least, from the Communist Party. But now I think that kind of autonomy has been vastly reduced. So those are, I think, two important processes to think about the Chinese the change in Chinese law. So I don't have much time left. I don't want to go over time. So let me just briefly mention the rest of the paper, which is like in the rest of the paper, I try to actually think about if now we see the Chinese legal system not as a bird but as a cage. Then what are the birds actually now confined in this new cage of Chinese law, right? So I use 4 different metaphors. I think there are 4 kinds of birds trapped in a new cage of Chinese law. I call them hawks, crows, sparrows, and ostriches. So I'll explain them one by one very briefly to just give you a rough idea about what I mean by these 4 types of birds. And then I will stop. So the basic idea is to think about the Chinese legal system not in terms of the doctrinal way, or not even in terms of the legal institutions, looking at the courts or the legal profession, or look at the People's Congress, for example, but to look at from the perspective of the users, who are the people, the individuals, or the groups actually influenced by the legal system, and these are the birds that I'm talking about. So the first kind of birds are what I call hawks. So these are the party state officials, basically party officials and government officials. And why they're hawks? Because I mean they're basically very powerful birds, right? But of course, as we all know, that after Xi came to power, he started this very large-scale anti-corruption campaign, right? Basically with a goal to, of course, to reduce corruption. But more importantly, I think there's a process going on which actually is legalizing the party disciplinary system, or legalizing the Shuangui system in the past probably 7 or 8 years. You see that very clearly. So here I have some cartoons. They're self-explanatory. I don't want to spend time on the cartoons. What I want to point out very briefly is just that in the party disciplinary system used to be something outside of the formal Chinese legal system, because I mean there are a lot of criticism on the party disciplinary system in China by kind of outside researchers say, oh, it's actually kind of extra legal, because like somebody can be official can be taken away into the Shuangui process for months or even 1 or 2 years without actually having legal representation, without even having any contact with family members. So that's illegal. That's actually legal, right? So and then what happened, of course, is that in the past several years, then especially with the establishment of the National Supervision Commission, the Jianchawei, but even before that, even when during the revision of criminal procedure law and other laws, there's a whole effort to legalize the party disciplinary system. So now it's actually become legal. So a lot of these kind of used to be party disciplinary measures now become part of the legal system itself. And that's, I think, a very good example of what I mean by party inscription, the concept I talked about earlier. So that's just a snapshot about the first kind of area of Chinese law. It's really about the laws for combating corruption. And the second type of birds I want to talk about are what I call them crows. So these are the political activists. And of course, the laws for controlling the political activists are the laws for the sake of political stability. So, and of course, I mean, this is a whole bunch of different laws targeting at different groups. And so again, here I have 2 kind of posters or cartoons. One is about feminists, one about lawyers. And of course, we have Professor Fu Haling here, who's one of the top experts on human rights lawyers in China. So, but human rights lawyers are just one of the many examples of the some people call them civil society groups, but I usually don't like that term, because I don't really think China has a civil society at all, right? So it's more like these kind of activist groups, like fighting for different kinds of rights, human rights, women's rights, environmentalism or labor rights, all kinds of activists. So they used to have quite a bit of room for mobilization or for collective action, 10 years ago at least, right? And there were a few years some of these groups are actually doing parallel things. They were using Weibo or social media to organize large-scale protests or large-scale collective action, or they call them action, 行动, or these kind of, there's even the term called 女权行动派, the action-oriented feminists. So there are all kinds of activist groups, quite active. And then, of course, these are the groups that pose threats to social and political stability in China, and that's one of the single most important thing for the party and the government, right? So if you look at the past 10 years, there are also this very clear efforts, legal and other efforts to control these kind of activists. And again, I don't have time to go into details, but these are very well known events. For example, the Feminist 5 or the 709 crackdown on lawyers, both actually happened in the same year, 2015. So after that, of course, and there are also kind of a series of legal change. I mean, there are things that are written into the criminal law, forbidding certain kind of mobilizing techniques. For example, lawyers used to be able to post on social media from the courthouse. Now they can't, right? But there are also other laws. For example, the foreign NGO law, actually targeting at the non-governmental organizations, the so-called the hostile foreign forces that used to be quite active in China supporting these groups. They were also actually now being kicked out of the mainland, now even being kicked out of Hong Kong, right? So there are all kinds of legal measures that are actually trying to targeting at these activists, right? So that's another area of Chinese law, what I call the laws for social political stability, is aiming at killing these crows, these activists. And the third type of birds I was talking about are, like what I call them sparrows. These are the internet users, the so-called netizens, the citizens on the internet. So, and of course, and this is not really an area of Chinese law in the technical term or the doctrinal term, but I think this is actually quite important part to a way to think about kind of how the cage of Chinese law works, because there are millions of internet users, billions of internet, probably more than 1 billion internet users in China now. And again, they used to have more liberty and more kind of ways to talk about things online in BBS, in forums, on Weibo and all these things. And of course, in recent years, you also see that kind of trend of a lot of legal and other measures to kind of constrain the online speeches mostly, and also of course online collective action as well. And for the sake of time, I'll just give one brief example, which is the cybersecurity law of 2016. So the cybersecurity law have many kind of very technical articles, but one important thing that the cybersecurity law did is that it actually legalized the online real name system. In other words, now if you're an internet user in China, you have to register, no matter for what website, with your real name, real national ID number, phone number, all these things. So whatever you do online can be tracked back to you. So that, of course, is a huge constraint on the online speeches. So you can see, Weibo, for example, used to be a much freer public sphere for discussing things and express opinions, and now it becomes a lot more controlled. And I still have a Weibo account, I still have followers, I can still post on things, but I think that the degree of interaction, the degree of constraint is actually very different from say 10 years ago or even 7 or 8 years ago, right? So that's, I think, a way. I think that you can see that again, the party state is using the legal system to try to control online speech. And very quickly, last point, and then I'll stop, which is I call them feeding ostriches. So these are the part of the law that really aiming at regulating everyday life. This is the vast area of civil law, for example, property law or marriage law, family law, or these kind of all kinds of civil law. So I call these kind of birds ostriches. These are just ordinary Chinese citizens. Because I think it's not unique to China. In the majority of the society, most people are not interested in politics. Most people are just try to make a living, try to make ends meet, try to live their everyday life, and try to get richer and make their their life happier, right? So I think that's, so a huge area of Chinese law is aiming at keeping these ostriches happy, keeping the majority of Chinese people actually getting richer, having better lives without actually looking at the political problems, right? So then, and of course, there are many other examples. I mentioned the Unified Civil Code just, finally came into being last year. That was actually, of course, a big achievement in the area of civil law, basically making the ordinary Chinese people happy. But at the same time, there's still a lot of very serious issues that, for example, consumer products, for example, like the gender inequality in marriage and divorce, all these things. And Professor He Xin at Hong Kong University recently published a great book about divorce, kind of showing some of these dynamics. There are many other kind of area of the Chinese law was actually under this category to how to actually feed ostriches to keep them happy, so that they will ignore all these kind of political problems happening in China, in the legal system and beyond, right? But of course, I think that's actually only half success. It's not really the party inscription, and it's not really as successful in this area as in the previous three areas. Although, I mean, in terms of the internal coherence, formal rationality, civil law is probably has the highest degree of formal rationality than other law. So let me conclude. Basically, what I'm trying to say here is that if you think about what happened in China in terms of legal system in the past 20 years, there's probably a legal modernization whole process going on. And as Taisu mentioned, this is kind of the vision of Chinese leaders for almost 100 years, to use law to modernize the country. But of course, as we all know from the great German sociologist Max Weber, there's iron cage effect of legal modernization. It's actually the legal system become more and more complex, and that actually become a constraint on society and on many other kind of parts of activities and social life, right? So eventually, I think if you look at this whole process of what I call Chinese law change from a bird, transform from a bird to a cage, you actually really speak back to what Stanley Lubman talked about in the Bird in the Cage article, which is this kind of hope, or maybe you can say illusion of law as a driving force for social change. A lot of people in the law and development camp, and people actually, especially coming to China or to other developing countries from the West, actually having this illusion of law can be a driving force to generate economic reform, generate social change. But what happened in China for the past 20 years, you can see this is not really happening. Law is become a lot more instrumental, and also a lot more repressive in a sense than it used to be. And so I want to end with this question. I think since now Chinese law is this much more sophisticated and hard and complex cage, it's very hard to break. But then the question is like, will there be a latch door for all these birds I talked about to actually go free, to enjoy a little bit of liberty under this new cage of Chinese law? I'll stop here. Thank you very much.
Thank you very much, Star, for providing us a holistic picture of Chinese law transformation from a social legal perspective. I really like these boats. I guess you must like boats very much. And okay, so now our next speaker is Professor Huaning Fu, and he's going to speak on how does law cope with politics. Professor Fu, please.
All right. Thank you very much. Good morning. Good evening. I continue to write on human rights lawyers, and a couple of papers I'm thinking about and writing is really about anti-corruption enforcement. So in this paper, I'm still writing at the very beginning, so comments will be most welcome. I want to go into the weeds. Look at the interaction between the parties, norm, enforcement, and the state law at the concrete case levels. So the methodology is, I mean, we all know this sort of a big data thing. So I asked my friends, so have some keywords, the party's disciplinary committee, inspection group, 巡视组. So what kind of cases that can be generated? Not criminal, just the corporate, labor. So there were roughly 3,000 cases with the title of inspection groups. So it's very difficult to read. The format is pretty bad. So I'm in the process of reading. So there are two categories of cases which I found quite interesting. Let me just share two cases. So from those two cases, say what I can get out from them in terms of developing a theory or some type of conceptualization about the party and the law relations, and in particular, the role of judges and courts may play in the process. The first case is a case of a demotion, right? So, by the way, I'm not, most of the cases, of course, are in the state-owned enterprises, right? So there's a small state-owned enterprise, a chief accountant. His wife, estranged wife, divorced already. Unhappy about this divorce, complaint to the husband's workplace. The party's disciplinary inspection committee made a few allegations. One, first, he took loan from someone, from a company he was not supposed to take, right? He refused to comply with court order, basically pay the wife of the divorce case. And among a number of very small things, right? So the party investigated and they made a decision. Right? The decision was gave the person a warning, right? 警告, and then took away his position as a chief accountant, right? And shifted him to a minor position, but keep this 科级 title. His professional certificate as accountant was also taken away by the party committee. So the party committee made a number of decisions, not the political, professional, and administrative. So naturally, he was unhappy. Interestingly, he didn't go through the party's process. He went to the court directly. The allegation, of course, is a violation of contract law. Right? There was a proper contract, and the contract was altered without consent, without good cause. Right? So that's the first case. The second case is about company law. Right? Let's say called a bonus case from Sichuan. There's a state-owned investment company had this scheme which gave bonus to the employees who was able to generate investment as a 10%, right? So this group of people was able to generate 250 million RMB. So according to the scheme, they're supposed to get 2.5 million RMB as bonus. So the bonus was halfly disputed, but in the process, there was a 巡视组 coming in. Right? The 巡视组 decided that scheme was politically incorrect, should be stopped. And then, of course, they stopped the further payment. So that employee was unhappy, demanding payment according to the company's charter, and also as the contractual obligations of the company. And then he didn't go through the 巡视组 process, of course. It's highly political. He went to the court. So those are the typical cases I'm looking at. Is actually at the intersection between the legal rights, according to either company law, contract law, and other law, property law. I think there will be other cases, and the political decision of the Communist Party, either in the form of a Xun Shizhou's decision, or in the form of a party's disciplinary committee's decision. So the first question is, how do we look at this party's mechanism, right? The decisions are made entirely out of the scope of law. Right? The party made a decision clearly according to the party's internal documents and the rules. So in a way, the decisions are normless. It's not law grounded. But then that doesn't mean it's normless. They're based on the party's internal norms. So they are. The process is very, very structured. It is highly institutionalized. They're quite effective, and they're also consequential. Right? Once the party, committee, or groups make the decision, the person's rights would be adversely affected immediately. And so there's the second sort of feature. The third feature is they're quite secretive. Right? Some of them try to get into the papers. Okay, show me the documents. What actually the party's committee said. What was the facts? What are the grounds? The court in other cases normally say, well, those are the party's internal documents. So they're either state secrets or they are party's affair, which the court have no business with. So, and finally, there's no remedies. The one of the interesting things that I'm still looking into it is whether those parties whose rights were affected, whether they go through the party's internal petition, a review process first before they go into the judicial process, or they simply decide to abandon the party's the petition process and directly go into the court. So the cases with clear facts tend to show that those affected party members simply go into the court directly without even thinking about resorting to the party's internal remedies, giving me the impression that probably the internal remedies, either there is no such thing about internal remedies or they are not effective. So the only thing, so for a party member, junior officials, when your rights were affected, the only thing or the first thing you can think about is going to the court to have a lawyer. So I thought that thing is quite interesting, right? Now, the second interesting thing in some of the cases is to say what kind of arguments lawyers would make in courts, right? That's quite interesting. Those lawyers are not the typical human rights lawyers I look at. They are just small town corporate lawyers, labor lawyers, but that they make like a fascinating argument from my perspective. Right? What they say, well, there are two systems. There are two types of regulatory regimes. One is political, another is legal. The party take care of its own in-house business. Right? They have their own mechanism, accountability, but then they have no business in what the court should do. Right? We go to the court only consider contract law, company law, not the party's law. So this is the first very clear argument. The second argument is whatever the party decides have nothing to do with what the judges should do. They're entirely separated. This is the second argument. And the third argument I thought is the most powerful is to the degree that party norms violate the legal norms. Of course, the legal norms should prevail and the party norms would not be considered in the first place. They're also making some interesting side argument. Right? So in one of the demotion case, they actually go through a lengthy process to argue in the court why the Communist Party misapplied its own rules. Right? They're making a legal argument on the party's norms and the application of the party norms in this individual case. And the judges listen and engage a conversation whether actually the party committee violates its own rules. I thought that is also interesting. So somehow you bring party norms into the judicial process, allowing judges and lawyers the opportunities to review the party's norms, which they have no rights to do in the first place. But somehow it's a collateral thing, right? Once you have the case in court, the judges will look at everything. Sometimes the judges say, well, it's not our business. Well, you go back to the party committee. But sometimes they do look at the party's norm. So in one case, for example, a person impersonate a disciplinary inspection committee members, right? It's a criminal offense, right? If you impersonate state functionaries. So the smart argument from the lawyers, well, the disciplinary inspection people, they're not state, they're party. Therefore, if I impersonate them, it will not be criminal offense. And then the judges would have to make a decision. Well, are those party members also state functionary or not? And they just make a very quick ruling. Yes, the party members working for the party, they work for the state. Therefore, they're state functionaries. So if you impersonate them, it is criminal offense. But it seems to me that is a significant decision. Right? I remember some of the cases in the late Weimar Republic, there was also the decision, whether the neo-Nazi party members of state are also member functionary of the state, and the decision was made towards another different direction. Right. So in the bonus case, for example, the lawyer made the very clear argument, right? Even state-owned enterprises are governed by the charters, by the company law. They are self-contained. They are autonomous. The party may have this separate internal proceedings. Because the party's argument in this bonus case was that, well, given bonus is not just a company's business, right? Under the party's rule, you have to report to the superior organizations. And in that case, the company failed to report to the party organ. Therefore, the measures, the rules, and the schemes were sort of illegal because they violate the party's rules, right? So the question interesting for me is what the judges are going to say, right? Facing the argument, right? Clearly, the lawyers are saying, judge, don't apply party's norm, right? There are clear legal rules in place. You should just follow contract law. You should only follow the company law, not the party's internal decisions. So every one of us probably will be surprised if the judge actually say that, right? But the interesting thing is, okay, what they say that some of the judges didn't really just say clearly, say, well, because the party said this and that, therefore we have to follow, right? One of the first instance court judge in the contract law case, the demotion case said, he said he is going to apply the party's norm, right? Why? The question he said is very sophisticated. He said, I'm going to read this in Chinese, right? So the party's decision 未超出一般社会理解，实际履行多年，被告人已知晓相关内容. So what I said is, we all know the party controls the state-owned enterprises, right? There's no surprise. So he said, this appellant judge, court judge said, no, you were promoted according to the party's rule. And you were very happy when you were promoted. You didn't challenge anything. You didn't ask any legal questions. Now, it is exactly the same process that demoted you, right? You shouldn't be complaining because that is our common understanding how things are working in the Chinese state-owned enterprises. Yes, there are laws, but then the laws are not really clearly, explicitly, directly violated. I mean, of course, it doesn't carry any water, this argument. So basically, he tried to make a very fuzzy argument. He is not saying I should apply the party norm or disapply. He simply said, well, we know what we are talking about. Right? We're in China. We're talking about a state-owned enterprise. So go away. Right? So that is argument. Another argument is actually on the bonus case. The judges simply say, yes, the Chinese state-owned enterprise are subject to the state company laws. But then, they are state-owned, the Communist Party can exercise leadership, so they have their own requirement. So what we can do is really defer to the political decision as long as they don't really clearly violate the Chinese legal rules. So they didn't make any clear argument on that. So my question here is, what can the judges do better, right? Can the judges demand, for example, through the ruling, other mechanism to make sort of a statement that, so in both cases, when I look at those cases, as far as I understand the company law and the contract law, the Communist Party should be able to, and is able to justify the decision not according to the party's norm, but also to take an extra step to cover or justify their decision through the legal norms. It is possible if they do it. In the contract law, for example, the demotion case, they simply need to do is to have a sort of to consult the labor union. But that obviously, I think they can always consult labor union and get them on board to agree with the party decision, right? In the company, the bonus case, I think it's very easy for them to say, okay, we made a decision, the board of directors approved, or we just approve another decision, say we'll do away with the bonus through the proper mechanism of the corporate governance structure. But they didn't do it. They're just so sharp, right? They make a decision and that's the end of it. So in a way, that probably Taisu was referring to, is there are decisions that can be justified through the proper legal norms, legal mechanism. But for the Communist Party, they simply were aware the disciplinary committee would not bother or don't do it because we are the party. Right? So in conclusion, I think I just want to raise a few questions. Right? One question is, so what are we talking about? Right? We're talking about state-owned enterprise. State law didn't really apply to the operation of state-owned enterprise until the 1990s. Right? The company law, the contract law, they are basically a political arm of the party and an administrative organ of the state. The state law didn't really intervene. So the larger question is, do we need law, right? So for example, do we really need a director of the board of directors in the state-owned enterprise? Since you have the party mechanism side by side, since they are making the real decisions, why not just go back to the old way of running the state-owned enterprise? Right? So that is one question. The second question is, well, if we're going to have some modern companies, they have very much legalized contractual relationship in the state-owned enterprise, so we may have to be more serious. So then the question is how to reconcile the party's intervention on the highly routine cases, which has significant bearing on the individual rights of the party members and the employees. So how the party should rethink about the governance structure, right? That goes back to Siddharth's question, right? Should the party hide behind the law, making decisions, but then cover decisions through the proper legal mechanism? Or do you have to, is it really necessary for you to make decision as the law, right, up and front? And then you create tremendous difficulties down the stream. And the lawyers will have to make highly political argument. Judges will have to make a decision, which it seems to me they're not in a position to make. So I will stop here. Thank you very much.
Okay, thank you very much, Professor Fu, for the very thought-provoking and critical analysis of the relationship between the law and the party, and in a storytelling approach. Okay, so okay, now I'd like to invite our next speaker, Professor Supplin, to speak on CCP inter-party regulations as a political and theoretical challenge. Dominic, please.
Yeah, so thank you so much for having me. Thank you, organizers, colleagues at CTU, for having me join this symposium and this group of scholars. So I also have some slides, and I'm going to share them now. Let me see. Let's go into presentation mode. So I guess you can see them now. So I'm going to do something that is a bit self-interested today. I'm going to solicit your views basically on a couple of research questions that are very puzzling to me. And they have to do with the party's internal regulations, which Dean Fu already discussed about. So, 党内法规. So I mean, for those of the participants who are not familiar with these regulations, what are they basically? Well, they are the party's internal rules. They govern party members' conduct and relations between party organs. So they comprise disciplinary rules and standards, types of disciplinary sanctions, processes for adopting other inter-party regulations. There are rules of recognition in these regulations. There are rules on the organizational hierarchy, rules on who gets to adopt these regulations, and so on. Okay, and reading a sort of published literature, in China at least, on this question, you might get a sense that this is a relatively unproblematic issue. Okay, so many scholars will agree that these inter-party regulations are underdeveloped at the moment, so there may be inconsistencies between these regulations. Some regulations, at least in the past, have been in a conflict with state laws. Some regulations are just too ambiguous, some are too detailed, some are too general, some are too difficult to understand, and so on. But still, the general sentiment seems to be that these problems can be ironed out. Okay? And these regulations can be reformed as part of a sort of natural rationalization process that will occur in any modern organization. Okay, so that's a common view, I think, at least in sort of published scholarship on this question. But that's not how everybody sees this issue in China. So when I first started studying these regulations, I guess in 2017, I was really surprised when I sort of brought these regulations and the reform efforts up with what I would say are sort of centrist, maybe liberal-leaning scholars as well, and they would get very agitated, okay, about this very topic. And it wasn't clear to me why that was the case, okay? So I would have thought that if you are at least a centrist scholar, you'd be very glad to see that these regulations are being rationalized and their enforcement mechanisms are being improved. Because, I mean, rule-based governance would be a sort of important value for that. Okay, but that wasn't the case, right? So that was very curious for me. Okay, so I found this topic very puzzling. I think it's the single most difficult to understand topic in Chinese land politics for me. So it's not hard for me to understand why the party places itself above the law. That I can understand. I can also understand the impulse of, like many party leaders and scholars, like a genuine impulse, which is to say that legality is a positive value, even if the party is above the law. Like, I get that. But there's something really counterintuitive about these regulations. So, we can talk about the politics of these regulations and then the sort of the theoretical explanation of what's going on. So I think I figured out the politics mostly, but there's still something really fundamental that I don't understand about these regulations. Okay, but nowadays I think that this is a sort of fruitful puzzle for me. Okay, so it's been fruitful in the sense that I've published, 3 pieces on this topic already, so the details are here. All right, so let me say something about the politics of these regulations, and how I see them. So the easiest political agenda for me to understand is this reformist agenda. All right, so these reform efforts, by party leaders and legal scholars who are sort of deeply embedded in this, in the party's sort of political project. And it does make sense to me why a party leader and legal scholar who sees formal legality as an important value would also then like to see these regulations being formalized and rationalized. Okay, so here on the slide I have some references to, well, I guess already dated literature, and these texts make the sort of point that party regulations have to be rationalized. They need to be rationalized in order to form a coherent structure with state law. Okay, these regulations may include standards that are higher than state law for party members, but they cannot be in a conflict with state law. Okay, so as Qin Qian Hung, for instance, says, maybe these regulations ought to be seen as soft law, or maybe they should be seen as policy considerations that are used to interpret formal state law, but they're not binding as such on courts. Okay, if there is a conflict, state law trumps party regulations. Okay, but the point is to ensure that those conflicts do not happen, right? So these regulations need to be adopted in a scientific and rational manner. They need to be formulated as law-like clauses, so they, the language needs to be sort of general, but not too general, and so on. And that agenda, I feel, is a sort of natural extension of that kind of, turn towards legality, to sort of use Professor Chang's sort of language here, all right? And I can get it. Why, somebody might think that these regulations are a kind of like a universal human good. So, they are a sort of natural progression in the modernization of a state. They prevent abuses of power. They reduce corruption. They enhance legality, basically, within the party organization. So all that is commonsensical to me. But it was far harder to understand why a liberal-leaning scholar and a centrist scholar would then oppose this kind of reformist language and actually these reform efforts. Now, why was that the case? I now think that what was troubling about these regulations for centrist scholars was this idea that if you reform these regulations and if you make them a sort of, like rational part of the, the normative apparatus of the Chinese state, then they will have a more prominent status within Chinese society. Okay, why is it a problem? Well, it's a problem because they will have a more prominent status at the expense of judicial processes, right? And specifically, these scholars were concerned about the establishment of the national supervision commissions or supervision commissions, which extended the party's disciplinary inspection system away from party organs to the rest of the state organs when the public use of power was concerned. All right, so for these views, I mean, they came up in sort of private conversations. I don't have sort of very on point citations for them. I just have a couple of articles by Professor Tung Chue, whom I haven't met. So that's just for reference. And there are other political agendas here as well. So there are these sort of avant-garde notions of notions which tend to oppose all kind of rule-based governance within the party because it somehow kills the vitality of party as a sort of social movement. All right, so politically, I don't think these regulations are too difficult to understand, but it's the theoretical explanation that is truly baffling for me. All right, so you could say that maybe these regulations work in practice, but they don't work in theory, right? At least for me. And the basic issue that I have is this. Okay, so does it make sense to say that the exercise of political leadership, which is meant to transcend laws, right? As Professor Liu said, the party is above the law, right? Can it nevertheless be governed by formal rules? Okay, so the assumption behind this question is that the party leadership is necessary because the party can suspend the law when that's necessary for some political reason. Okay, that's the very point of this form of party leadership. Okay, I know that that might be a little bit controversial issue in China, and some lawyers might say that no, the party is never above the law, but that's my assumption. I think it's sort of a realistic assumption regarding what the party is even meant to do, even according to its own sort of ideology. Okay, so if the party can suspend formal state law, the question is, can it also suspend its own regulations? Right? Because why would there be a difference between formal law and formal rules and nominally non-legal processes? So why would there be a distinction between sort of nominally legal processes and nominally non-legal processes? Right? They're all just formal rules. Okay. So if the party can suspend its own regulations, we have some very sort of juicy paradoxes in our hands. So on the one hand, the party presents itself as a modern organization, and actually it is, right? In a sense, a modern organization, right? It is constituted by its own regulations and by this sort of norm-following conduct, right? But on the other hand, okay, it does seem unlikely that these regulations are actually meant to be binding in all instances within the party. So just like formal state law, also these parties' internal regulations are over-inclusive and under-inclusive. Okay, so the rules don't achieve what the party leaders would want them to achieve, always. For instance, some inter-party regulations require that party members observe formal state laws always. Okay, there are rules that say that a party's disciplinary process may never be coercive, right? So you may never coerce a party member in interrogations. Okay, so one wonders how sort of literally those rules are meant to be taken. Okay, and also, isn't it the very point of this kind of political leadership that it's not held back by formal laws and by formal rules, right? When political expediency requires that's not the case, right? So I don't think there are good answers to these questions in the literature that I'm familiar with. So here on the slide, I have some references to classical texts on this question. Okay, so as I mentioned, and as already has been brought up today, most Chinese legal scholars understand these inter-party regulations and their reform efforts through this Weberian rationality process. Okay, so Max Weber thought that a modern political party will include elements of rational legal authority. So that means that there's an expectation of continuous rule-bound conduct within the party. It means that political parties, so here the Communist Party, comprises specific spheres of competence, that the offices within these parties are organized through the principles of hierarchy and so on. So that might sound like what is going on in the party, right? But also maybe it doesn't sound like what's going on in the party. So I do wonder how realistic that Weberian model is when it comes to describing the uses of authority and power within a Marxist-Leninist party. Okay, and the basic, question that I have here is about the sort of culture of formalism, right? If I may use that term, that this model requires. Okay, so Weber explicitly says that under this form of rational legal authority, there is an expectation, right, that rules are applied consistently within the political organization. Okay, so your political opponents, right, will have exactly the same rights as you have as well, right, and your supporters have as well, and that's like an actual expectation within this kind of modern bureaucracy. Okay, so does that kind of culture describe a Marxist-Leninist party very well? Well, maybe it doesn't. Okay, so I understand that there is nuance in this, so perhaps you could say that these instances where the rules are not followed are rare exceptions, right? So that's possible. But if one takes a look at these regulations, they are oftentimes just so sort of loosely formulated and just so sort of vague that it's very questionable to me whether they can even form a kind of Weberian sort of rational cage, or that sort of like rational clockwork, right, that produces decisions through the rules alone. Okay, and also if you consider the concept of democratic centralism, right, which is like a major organizational principle in the party, it's not clear to me that it's a rule that decides what needs to happen. It seems like it's the interpretation of the rule, right, that is decisive here. All right, so the Weber's model here, I feel, doesn't really capture the issue. Okay, now the same goes for other sort of classical descriptions of the use of rules in a Marxist-Leninist system. So in particular, Yevgeny Pashukanis's writings on technical regulations. So Pashukanis was this Soviet legal scholar. He ended up being executed, so he was sort of a heterodox figure, and he argued that law can never be authentically socialist. Okay, so law will always be tainted by its capitalist origins, even in a socialist country. Even if you call a law socialist, it's going to be tainted by its capitalist origins. However, even in a socialist system, you can make use of technical regulations, which can be authentically socialist. So he made this distinction between law and technical regulations. Okay, but again, I just find it very improbable that regulations that you can call them technical regulations, like Dangne Fakui, that they would be applied to the letter, right, in that sort of technical way within a political party like this. All right. So many scholars nowadays conceptualize the Chinese legal system through Ernst Frankel's dual state concept. Okay, so what is the dual state? Well, it includes two elements. There's the normative state and there's the prerogative state. So the normative state is the formal state law, okay, which applies until the prerogative state, okay, which operates outside any kind of legal rules, decides that the normative state doesn't apply anymore. And Frankel basically combined this Weberian view of rationality with Carl Schmitt's idea that the political, like what is political, is always outside any kind of norm-based governance. Okay, so that's fair, right? And it kind of makes sense. But again, the intra-party regulations are a problem for this model, right? Because basically what you're saying is that within this, excuse me, I checked my chat messages. So what you're saying is that within these, within the prerogative state, they're actually a dual state, right? There's a dual state. So now we're saying that within the prerogative state, there are rules, okay? If we take inter-party regulations seriously. Now, Frankel himself wasn't very clear about what the role of rules was within the national, Socialist Party in Germany. So he has some pretty unclear statements about what rules achieved in the National Socialist Party. He said that the National Socialist Party at the same time made use of rationalist governance methods while its governance project was irrational. Okay, so what does it mean? Like if your governance project is ultimately irrational, right? How can it be constituted by rational rules of governance? Okay, so I think Frankel was sort of ambiguous on this issue. Now, finally, maybe we can just assume, as a sort of definitional matter, that the political will always be a sort of state of exception where rules don't apply, right? So as Carl Schmitt said, maybe political is precisely the instance where rules do not apply, okay? So by definition, there are no rules within the political, okay? But I mean, is that now a good sort of theoretical explanation of what this project to rationalize party governance is, right? So where does that leave us with these inter-party regulations? Okay, as a definition, we may sort of sympathize with that kind of a statement, but still I don't feel that it sort of solves the fundamental question that I have here. All right, so I'm going to conclude here. Let me just say that I was very first I was very troubled by this sort of theoretical confusion, but now I've just learned to sort of embrace it and enjoy it. So I can just get onto the meta level and say that inter-party regulations are fascinating because they make the paradoxes, right, within this modern illiberal governance project obvious. Okay, so we have this political leadership that is meant to transcend laws, but that is nonetheless constituted by rules, except that it's not. Okay, but I'd like to be more honest about this issue as well and say that I'm not sure if our own theoretical models explain what's going on here. Okay, so I'd love to hear comments from you, and I'm just going to leave it here, and thank you very much.
Thank you very much, Samini, for the wonderful theoretical discussion on this very important issue in China, the CCP's regulations. As we can see, CCP, I think it does take its regulations seriously. Now, even there are some PhD programs in mainland China for the study of CCP regulations. Okay, thank you. All right, so now let's invite our next speaker, my colleague, Professor Jiangyu Wang. And I think he is going to move on the other side of Chinese law from an international perspective. And he is going to talk about China and international law, instrumentalism, authoritarianism, or traditional Westphalianism. Jiangyu, please.
Thank you very much, Peter. I have very much inspired by the previous presentations. I made one-page slides on spot. I didn't prepare presentation slides at all. But I think it's better to show at least the terminology that I'm going to use here. Okay. So you can see the one-page slides. The theme for our symposium today is authoritarianism. Two streams of my own research involves authoritarianism. One is in Chinese the comparative company law, especially the corporate governance in state-owned enterprises. So the Chinese system, economic system, has been characterized as state capitalism, and but now the term state capitalism is being replaced by another phrase, that is authoritarian capitalism. And the other one is the other area of my research involving authoritarianism is actually quite new. So that is international law. Very much because thanks to a recent work of Professor Zhang Taisu's co-author Tom Ginsberger on authoritarian international law. Traditionally, we don't very much talk about authoritarianism in international law because international law considers the states as the primary actors, right? So the state as a black box. The international law does not very much mind what the state does within its boundaries. So it's actually quite happy to treat states as black boxes. So it doesn't matter whether you are a democratic regime or a dictatorship. As long as you practice or you violate the same international law. So international law has been considered as something inherently universal. So there's only one set of international law, one universal international law. So that does not very much matter. So who are the actors? So the but the rise or the emergence of the authoritarian international law is probably making a change, although the analysis to me is still at the very much at the nascent stage here. But so there now it looks to me to understand the Chinese approach to international law, if there is a Chinese approach to international law, it looks quite messy at this stage. A glance at the literature might generate three analytical frameworks, three theoretical frameworks to understand Chinese approach to international law. So the first one, the one is instrumentalism, and the second one is the Westphalia traditionalism, or the traditional Westphalianism, and the third one is the Tom Ginsburg's authoritarian international law. So I will briefly discuss these three lenses, these three perspectives, and then I will make some concluding remarks, concluding thoughts, based on my understanding of the Chinese practice in international law. So the instrumentalist approach to international law is actually quite simple. It simply means selective compliance. So a state chooses to comply some rules of international law, and to follow some procedures in international law, but not others. Right? So in the Chinese practice, you can see China probably has a better record in complying with international economic law, especially WTO law, but not very much a good citizen on sovereignty, territorial disputes, sovereignty-related territorial disputes, and arguably also on human rights issues. Right? So, it is probably also the kind of pragmatism. So, but from a global perspective, instrumentalism is not new. So it's not unique to China. It actually probably applies to every nation, especially the major powers. So instrumentalism is not a failure of law, and it is not a sign of weakness, or is not even a problem to be fixed from the perspective of international law. So it is actually probably a regular feature of the international legal order, right, today. So the instrumentalism is a matter of degree. So maybe some countries have better records in complying with the international law, and they are willing to be binding upon the wider scope of international law. Well, China, as arguably an authoritarian state, is only willing to be subject to a very narrow scope of international law. So that is the first framework to understand the Chinese approach. The second one is the traditional Westphalian approach. So the modern international law, any student of international law would know that the modern international law, modern system of international law is based on the Westphalia principles, right? And which is further premised upon the existence of the nation states. So nation states are equal sovereignties. So they are equal to each other. We don't have the world government. We don't have a supranational government above all of them. So they are equal to each other. So they have to follow two principles. One is sovereign equality, as I mentioned. The states are equal to each other and have to respect each other's sovereignty. And the second one is non-interference. So because we are equal, right? You are not above me. You are not superior to me, so I'm you cannot you cannot interfere in my domestic affairs, and vice versa, and then vice versa, right? So our international order today, the international law being one of the key components of the international order today, is based on those Westphalia principles. So some scholars have argued that China is actually, if you look at China's compliance record in international law from a longer perspective, for example, in the past, since the PRC was established, right? So China has actually quite a good record of being a traditional the Westphalian country, because China has always emphasized on sovereign equality and non-interference, and China does not only say it, it also practices it, right? So although things are changing probably in the past few years, so there are signs in international law to suggest that in China's practice of international law to suggest that so China has started kind of stepping in other countries' domestic affairs in order to defend its own national interest, but China largely follows non-interference, right? And in this regard, its record is much better than the U.S. and a few other Western countries, right? So there's such an argument that China is more Westphalia than the Western countries. Quite interestingly, according to the international relations scholar John Eckenberry, the Westphalia traditionalism is actually an indispensable part of the liberal international order created and underwritten by the United States. So if China is a Westphalia traditionalist, then which means that the Chinese approach is not very much an outlier of the liberal international order, right? So the third framework, the third lens, the authoritarian international law, recently coined by Tom Ginsberger, published last year in the American Journal of International Law, says that we have to. So there are different types of international law. You have the pro-democratic international law, and you have general or regime neutral international law, and you also have authoritarian international law. And the Chinese approach is authoritarian international law. These are not about different classifications, different types of international law per se. So it's not that we have separate international laws, separate international legal systems. It looks to me that Ginsberger is actually talking about the purpose of the use of international law. So for what purpose you use international law? If you use international law for the purpose of protecting authoritarian values and to maintain, to make sure your own regime survives, right? So for the purpose of pursuing regime survival, then you are authoritarian, right? If you want to use international law to promote the universal values, democratic values, then you are pro-democratic, right? So that's a little bit self-serving, but self-serving argument, but it has become very, very influential. So these three lenses to explain, to understand the Chinese approach to international law. I would very quickly actually conclude with a few of my own thoughts on Chinese approach to international law. First, is there really a Chinese approach to international law at all? Right? It's too early, as Joan Lai said, it's too early to tell, because it's at the current stage, it is it is very much a hybrid of many things, and a hybrid of many things. So you see idealist elements, and you also see the realist elements, and you see a lot of the tradition, you see Chinese characteristics there, right? Chinese characteristics there. So if we can, in some way to streamline our understanding of the factors affecting a Chinese approach to international law. So there are probably a number of factors. For example, one factor is some kind of idealism. So China's approach to international law, especially international economic law, is still driven by the Chinese belief in the global free trade system, right? The global free trade system. So the China is, at least rhetorically, China is a defender of the free trade system, of the even the liberal international economic order, and especially in recent years, if we look at the practice, China is not an destructive force in the liberal international economic system. The US is one. The US is one. This is very much because China has been a beneficiary of the liberal international economic system. So this might be and the idealist element. Of course, one can argue that this is also driven by instrumentalism, right? So there's also realism driven pursuit of power. So China has determined to become a great power, to become, somebody would say, become the top power, the dominant power in the world. Although I do have some reservation about it. And for this purpose, so China will only accept and apply the rules of international law, which can help it to expand its power, right? And another factor is China's approach to international law, international institutions, especially to international dispute settlement system, is very much driven by the victimhood mentality, right? So the sufferings, the memory about the South China's sufferings during the century of humiliation, which very much strengthened, solidified, and to a large extent exaggerated by the state propaganda in order to build legitimacy based on nationalism, has made victimhood mentality actually a very important, maybe even a major factor in the Chinese approach to international law. And of course, there's another factor which is probably most closely related to the theme of the symposium today, is domestic understanding of the rule of law, right? So if the objective of international law is to achieve rule of international law or international rule of law, right? So rule of law precisely rule of law in international society, then how come a country which doesn't, which has not fully subscribed to domestic rule of law can have obligation based, can have can fully accept, right, international rule of law, right? So very quickly on some new recent developments. I think the recent Chinese practice in international law, recent developments are mainly embodied in the Belt and Road initiative and the associated, the separated but still associated related concept of 人类命运共同体. So the community of shared destiny of mankind. There are a number of translations. So the Chinese approach has demonstrated several features. So they were several kind of emphases, right? One is the emphasis on cooperation and and partnership, right? So cooperation, we form partnership, and we resolve our disputes through consultation and consensus. So the Chinese approach is actually quite clear. The Chinese practice in the Belt and Road approach, I had a paper published 2 years ago about the Chinese approach to interstate relations along the Belt and Road, so which I characterized as a partnership-based relational approach. Right? So the common theme is the avoiding hard commitments, right, under international law. So it has become rather clear, rather explicit, conspicuous in recent years. So the where does it go? Driven by all these factors, many of them contradict each other. We don't know. It's too early to tell. But if you look at the results, is it necessarily bad? Or the Chinese approach is necessarily worse than the American approach? So hard commitments, but with American exceptionalism, right? So the U.S. As I mentioned before, the U.S. has created the international order, post-World War international order, and is also the vanguard of the international order. But every student of international law also knows the famous American exceptionalism. So the U.S. probably does not very much follow its own rules. So compared with that, if you look at the results, the Chinese approach has appeared to be more constructive. Right, to be more constructive, and has led to it's unlikely for the Chinese approach to lead to disastrous results. But on the other hand, whether the Chinese approach is the sustainable approach is very questionable. Right. So I would stop here. Thank you very much.
Thank you very much, Johnny, for addressing a truly interesting issue. Okay. So now it's me, and I share the screen. Okay. So what I'm going to talk about is a theoretical issue focusing on authoritarian legality and legal instrumentalism in China. And you can see a brief definition here. And also, Taisu just shared his very insightful thoughts on this. Taking China as an example, there's no doubt that tremendous efforts have been made to establish a comprehensive system of positive law in China, right, which has pragmatically strengthened the legal elements as reflected in the rational legal tradition. In fact, the rational legal authority, as defined by Max Weber, entails that superiors are subject to rules that limit their powers. In this regard, it may be argued that authoritarian legality is ultimately contradictory or oxymoron, since legality requires institutionalization, predictability, and certainty, all of which function to tie the hands of autocrats, while the rule of law under autocracies is bounded, limited, and unstable. Such a view, I think, has consciously placed the law, mostly understood from a liberal rational legal perspective, as differentiated or substantially separated from politics. In fact, in my understanding, authoritarian legality indicates a hybrid body of law and politics in an authoritarian regime, the meaning of which may be better identified in the context. On the one hand, legality indicates legal elements that have been incorporated into the authoritarian regime, although it does not signify a degree of predictability and certainty that is identical or comparable to a liberal rule of law order, right? The legality entails legal rules being imposed on the exercise of powers by superior authorities aimed at facilitating the efficiency of state governance. On the other hand, the authoritarian element in the term indicates a political condition of legality, one primary purpose of which is to maintain an authoritarian regime from a political point of view, right? In other words, although the law applies to all powers in principle, it is in fact subject to and may give way to political expediency in practice. As the entire enterprise of the law is politically controllable by the regime from the lawmaking to the final education, right? So in order to illustrate the dynamics of authoritarian legality, two pure types of authoritarian politics could be delineated. One is normal politics and the other is exceptional politics. In normal politics, the law is relatively stable and predictable, particularly as regards relatively apolitical matters such as regular economic and commercial activities, normal social matters, etc. In this situation, the approach to the law is largely rule-based or rule-oriented. Although the law itself may be enforced at the discretion of political actors to some extent, right? Of course, due to the contingent nature of authoritarian politics somehow, right? The meaning of law as is relevant to dominant politics in whatever sense may be practically defined in a contingent way. Moreover, relevant state actors may enforce the law in different ways under different circumstances, arguably at this actor's discretion, right? In this regard, functionally, law on the one hand may subject political actors to legal rules, for instance, for the purpose of administrative compliance, as is essentially required for normal politics. On the other hand, law may reserve a place for the politically expedient exception that may arise due to socio-political reality. And this political expediency, which the law is inherently required to respond to under an authoritarian regime, actually determines the unique nature and structure of law in an illiberal context to a certain extent. So of course, exceptional politics has nothing to do with temporal frequency in practice. It is possible that exceptional politics may be more prevalent under some circumstances than others. For example, during the periods of nationwide political movements or campaigns to facilitate consolidation of power immediately after secession in order to subdue potential challenges from rival factions, etc., right? So accordingly, law may be defined temporarily in different ways compared to the situation in normal politics. In exceptional politics, the meaning of relevant laws in normal politics may be adjusted, redefined, or even suspended, usually through legal means such as statutory interpretations or SPCs, judicial interpretations, etc., right? In order to accord with specific social political goals, right? So in principle, legal instrumentalism has enabled both normal and exceptional politics to be incorporated into the broad domain of law on the surface, meaning that the political rhetoric of law, such as the rule of law, etc., can still be sustained rhetorically via propaganda during times of exceptional politics. Right? More importantly, the legal means through which normative law can be defined and specified by autocrats, both spatially or temporally, may be more pragmatically effective than other non-legal means when it comes to achieving certain specific social political goals. although law in a liberal context without a politically independent court system, is often inextricable from politics. Anyway, the law still serves as a crucial instrument for distinguishing lawful from unlawful issues in such a way that legality can be practically delineated and established. So it can be seen that authoritarian legalities to some extent dictates the ways in which law may work uniquely for authoritarian regime. And indeed, at least ostensibly, law is considered as an impersonal means of governance that differs from other non-legal means. It is in this sense that the more respect for the law is in the people's minds, the more maybe perceived legality and legitimacy the regime may gain and cultivate, as Taisu mentioned, right? In order for this to occur, sure, we can understand periodic nationwide propaganda regarding law and its importance or the like, whatever form it may take, is a key element of the authoritarian political agenda, right? And more importantly, authoritarian legality is largely institutionalized from the lawmaking to the final education through a politically controllable Congress, or whatever you call it, right? And a court system under authoritarian regimes, right? So, authoritarian, we can see authoritarian legality focuses primarily on the instrumental rather than transcendental facets of law, as is reflected in the theory of legal instrumentalism. Sure, there has been actually increasing agreement with the idea that law as a man-made object varies across time and space as reflected in cultural relativity. And this represents, a significant departure from most pre-modern theories of law, which hold law to be sacred or natural, in essence, not man-made, right? As a result, the legitimacy of modern law actually has become much more instrumental and pragmatic, with fewer magic characteristics than before. And this actually is evidenced by the paradigm shift of legal theory towards a increasing prevalence of so-called legal realism, the pioneers of which include Roscoe Pound or Carl Luvening, among others, right? This shift has grounded the theory in experience, representing a substantial difference from metaphysical claims that postulate the existence of a reality beyond human experience. And this tendency has been elaborated in the legal theory of instrumentalism, which have been even referred to as the fourth great tradition of Western legal theory, in addition to the three classical ones. And moreover, the primary task of instrumentalism is the provision of a coherent body of ideas about law that make law more valuable in the hands of officials and practical men of affairs. And actually, this largely follows a philosophical logic of pragmatism, which centers around human beings and their purpose and actions in the universe, right? So legal theory actually has become a political, instrumental, or pragmatic discipline as opposed to a religious, moral, or historical one. So given the legal instrumentalism has shifted its focus on law as it is grounded in human conditions, thus separating itself from those Western religious, historical, and cultural traditions, it has become far more reflective of a non-Western context. And at a general level, the nature of law as an instrument for achieving social goals has found a widespread resonance that extends beyond the differences between the West and the societies outside the West. So in this vein, there are a number of questions that address a pragmatic facet of law, but are largely ignored by classical legal theories that may come into play for legal instrumentalists. For example, what complexities are contained in the law's model of operation, right? Of course, this is not to say that the inquiries arising from legal instrumentalism have become completely sociological, concern themselves only with raw facts, and therefore have nothing to do with the value of law in itself. Regarding the theory of value, instrumentalism inherently incorporates a tenet that it exalts the wants and the interests of the many, not the few, right? And moreover, the maximal satisfaction of wants and interests prevail over the free pursuit of gain when these two principles conflict. So the value placed on these principles has actually gone beyond the religious and historical roots of Western jurisprudence, with the result that they resonate to a certain extent in a non-Western context with no history of Western traditions. In a different context, of course, the content of legal frameworks may be different. For example, legal instrumentalism as situated in the US is premised on American experience and the unique American judicial supremacy model, right? In this vein, the idea that American instrumentalists are rule skeptics is clearly located in the US context, right? So this is clearly different from, for example, legal instrumentalism in non-liberal regimes, where courts may function as political subordinates for the sovereign authority, right? Therefore, at a general level of description, the primary focus of legal instrumentalism on the pragmatic facets of law extends beyond any particular ideology or tradition. However, if placed in a certain specific context, its instantiation may vary from one ideology to another. In theory, there could be three pure types of instantiations of legal instrumentalism based on the variance of political ideologies: liberal, apolitical, and illiberal. So, and having said these, Marxism and Confucianism, both of which are quite relevant to contemporary China, may also be relevant to the scholarly inquiry into Chinese legal theory. Of course, contemporary China officially upholds Marxist ideology. However, I think China has deviated from Marxist traditions in many respects, particularly since 1978. And it's clear that traditionally Marxist legal theorists, in fact, paid little attention to law. Moreover, the principal aim of Marxist legal theory was to criticize the centerpiece of liberal political philosophy, namely the idea known as the rule of law. And the Marxists regularly questioned the need for law and further contended that there would be no law in a truly communist society. However, we can see since Deng Xiaoping initiated the reform era, the law has come to play an increasingly important and instrumental role in China's economic development. And with the development of positive law in China, even the class struggle ideology to some extent has been replaced by the ideology of legality, in the sense that the antagonistic politics of illiberal regimes have been further legalized by law and legal institutions, right? This means that those exhibiting a politically intolerable hostility or who challenge to the regime, particularly if this challenge is substantiated, may be purged as criminal offenders by legal means. And moreover, with reference to the Marxist tenet that law is an instrument of class operation, legal instrumentalism does have a place in classical Marxist legal theory in the sense that the law is treated as a political instrument. And furthermore, internally, legal instrumentalism has some redolence with historical Chinese legal traditions. In fact, from the perspective of both the Confucian school and the legalist school, law was treated as a secular instrument that by no means has any transcendent meaning as derived from natural law, religion, or rights, in contrast to historical tradition in the West. So to the Confucian law is largely a means of enforcing the right, and litigation is traditionally discouraged. And moreover, although the rule of law in the legalist school appears more important than in the Confucian school, the law is in fact used merely as an instrument to maintain a legal order, ruled over by the emperor, and by no means operates to exert limits on the powers of rulers, right? And the traditional Chinese culture idealized and aspired to a harmonious society free of litigation and internal conflicts, right? And furthermore, in the 21st century, due to the new wave of advanced technological developments, including the AI, etc., I think instrumentalist thinking within the law may be further advanced. Okay, to conclude, unlike the liberal instantiation of instrumentalism posited within liberal ideologies, the illiberal instantiation of instrumentalism in China contextually a more, I think, a more explanatory framework than either Marxist or Confucian legal theories, reveals the law's nature and function as a crucial instrument for developing the enterprise of legality grounded on illiberal principles and constructed with the aim of facilitating China's development and furthermore favoring the cultivation of legitimacy for the regime, as Taisu mentioned. Okay, that's all I want to say. Thank you. Okay, now let's move on to the closing session, and I will be very brief. First, I'd like to say thanks again to our speakers for your informative and insightful presentations, and to the audience for your active participation. And moreover, after the symposium, as Zhang Yu mentioned, we hope to publish our discussion in an international journal, and we will follow up with our speakers with details about the publication issue after this symposium. And hopefully the discussion could be beneficial to more audiences. And and due to the pandemic, we are unable to hold the symposium on campus, and absolutely we hope to have a chance to host our distinguished guests on campus in the future. Okay, that's all for today's symposium. Thank you very much, and see you.
Thank you all, everyone. Thanks. Thanks.
Thank you very much.
Thank you.
Thanks so much. Thank you.